I'm Gene Adams, President and founder of Alpha Omega. Most people think that having a will is enough to eliminate any type of a probate process. The problem is, with a probate process, your family ends up spending years, sometimes, as well as thousands of dollars to get your hard-earned assets. We're going to set up a living trust for you, which will allow you to control your assets the rest of your life and make it very easy for your family to have the assets immediately. My wife Judy and I started the company going on 25 years ago to educate people on how to avoid the probate process. Over the years, we've helped over 40,000 people get their estate plan taken care of. First thing I want to do is I want to spend a few minutes and talk to you about probate. What is it? How does it work? Why do all the experts tell you to avoid probate? It doesn't matter who it is, Newsweek, Businessweek, Forbes magazine, the Wall Street Journal. They all say the very same thing. They use the same word actually. They say take control of your things. Do not let the government get involved. That's what this is about. A lot of folks come to the seminars and they'll say, well, we don't have to worry about this. We have a will. A will is nothing more than a letter to the probate court. It's better than nothing, but it's a guide to the probate court. And what that means is, after you die, 3 bad things will happen. The first thing that will happen is, the family will end up hiring an attorney to go through the probate process. They'll spend thousands of dollars, and in most cases, well over a year to get these assets you've left them. The reason the experts tell you to do a properly prepared revocable living trust is with that document, your family will inherit your assets immediately without having to hire an attorney, without spending time, and without spending a lot of money. The reason for that is you've taken control of things rather than leaving it up to somebody else. This is one of the questions we typically get asked at our seminars. This says, I have a will and my son gets everything when I die. He won't need to go through probate, will he? He absolutely will. A will is a letter to the probate court. That's what you're trying to avoid. We're not trying to say that he won't get the assets. What we're saying is it's going to take a long time and cost a lot of money. The reason the experts tell you to do the trust, like I mentioned previously, is that it eliminates the probate process. This is a revocable living trust. Revocable means you can change it anytime you'd like to change it. You're going to change it. Life changes, assets change, family members change, everything changes. It's revocable. It's a living trust. It lives with you for the rest of your life. You're not going to start the process and 5 years later need another when you have one. You're not going to move to another state and need another trust. You have a trust. This trust lives with you for the rest of your life, protects your assets all over the country for the rest of your life. Now you are the trustor of your trust. That means you own it. You've created it. You'll give your trust a name. You can name it anything you'd like. Normally it's your name, but you could put any name on it. Ours is easy. We're the Adams family. We call our trust the Adams Family Trust. You'll call yours whatever you'd like to do it. You then will appoint the most important people. The most important people are called trustees. The trustees are the people that control everything. The trustees buy things. They sell things. They open accounts. They close accounts. They change things. You will be the trustees of your trust. My wife and I are the trustees of our trust. The legal description of our trust is Gene and Judy Adams, trustees of the Adams Family Trust. Now we get on with our life. We do what we want when we want. We buy things and sell things. We open accounts. We close accounts. We change things. We make every decision as long as we're alive. If we need help, we call to get assistance from our offices. If we have questions, we call. Part of our service is you have ongoing consultation for the rest of your life. That's a big deal for people. You will have questions. My wife and I mentioned we've had our trust for 25 years. We've made 2 changes in 25 years. It had to do with grandchildren. We did not have grandchildren. We did our trust. We now have grandchildren, and we wanted assets to be distributed to them in a specific manner. That's why we did that. Now, after I die, my wife is still the trustee. Judy doesn't have to change things. She doesn't have to go through probate on any assets that are held separately. She just continues on with her life. If she has questions, she calls. If she needs help, she calls. Nice thing is she continues on as the trustee of the trust. Now, things change after Judy dies. Whether Judy and I die in an accident together, or whether Judy dies 30 years after I die, this trust changes. This revocable living trust becomes irrevocable. That means it cannot be changed anymore. The reason for that is we've died. We don't want our kids to change things. We want our estate settled. So we've appointed what's called a successor trustee. Now this successor trustee can be anybody you'd like and can be as many people as you would like. I've had people appoint some of the children, none of the children, all the children, churches, financial institutions, brothers, sisters, grandkids. It's totally up to you who you appoint to do this. You can appoint as many people as you would like. If you appoint one person, it's very likely we'll ask you to appoint an alternate just in case something happens to that one person, so there's somebody else to fall into place. Judy and I appointed our 2 children. They are called co-successor trustees. That simply means they're going to do everything together. We could have appointed one or the other, but we chose to appoint them together. We also spend a great deal of time with our family, so we have appointed an alternate. Just in case something happens to all of us at one time, there's somebody else that will be able to fall into place. This is what our 2 children will do after Judy and I both die. Now, this is exactly what they're going to do. They're going to take one section of this trust. It's called the Declaration of the Trust. It's a couple of pages. It identifies us and them. It says what their powers are. They're going to take that. They'll take identification. They will take both of our death certificates. That means we both have to be deceased, not one of us, but both of us. They will go down to the county clerk and walk in and say, our parents have died. As you can see, we're the trustees of the trust. Please put the house in our name. It's immediately transferred without any delays, without a bunch of costs, and they get on with their life. They don't need any people to be involved with this. They don't need attorneys to be involved with this. They take over. Remember, they become us, actually. It's kind of like a business. When Sam Walton died years and years ago, the state of Arkansas didn't step in and say, Billy gets to run Walmart, did they? No. Because Sam Walton had a successor in place. The successor stepped in to run Walmart. That's what you're going to do. You're going to have a successor in place. That successor is called a successor trustee. And they're going to step in and become you for the purpose of settling the estate. In our situation, our children will then go to the banks, the financial institutions, any place there's financial assets. They'll do the very same thing. They'll do this quickly. They'll do this without spending any money, and they'll do it privately. Let's say Judy and I have $50,000 at Bank of America and we die. Our children go down to Bank of America and say, our parents are dead, give us their money. What do you think Mr. America is going to say to them? He's going to say, I'm sorry they're gone, but the account is frozen. It will be released through the probate process. So the kids scamper off and say, we'll see you in a year or so, and they go through probate. Not in our situation. Our family will have those assets immediately, and they'll get on with their life. And the reason they can do that is because we prepared the document properly, but we also made sure the assets were in the name of the trust that we control. And then after we die, our successors, remember, step in and become us for the purpose of settling the estate. This section is actually kind of like the presidency. You know, it doesn't matter who the president is. It doesn't matter if you like them or you don't like them. But if the President of the United States dies today, we're not holding another election next week, are we? We have a vice president to step in to take over. That's what you're going to do. Your vice president is called the successor trustee. And they're going to step in to facilitate things and get on with their life. Now, we have another section in our trust that's different than any trust I've ever seen. It's called the Guide for the Successor Trustee. We actually tell your successor trustees, so in our case, our 2 children, we tell them what to do, when to do it, how to do it, in the order it should be done, and in plain English. How to settle debt, how to handle the IRS, what to do about Social Security, how to handle military papers. We walk them through the entire process. But you know what another nice benefit is? If they have questions and they need help, they can actually call and we will assist them in settling the estate without any additional fees. That's a big deal for people because oftentimes people do have questions and they want to get as much help as they can get. You know, another question that we get asked often during our seminars is this. I have a daughter's name on my house as well as our bank accounts. She'll get those assets, won't she? The problem is you have her name on the assets. When you do that and you've combined assets, 3 bad things happen. The first thing that happens is you've lost control of the asset. If you want to sell your house, you got to get her permission. Now, she may give you the permission, but I don't want to do that. You may also be in a position where you put her name on the bank accounts. Again, she has access to those bank accounts while you're alive. When combining these assets like that, these are issues that you cannot avoid. I've had people come to seminars. I had a couple come to a meeting one day. They said, we put our daughter's name on our house. We decided to sell our house and move. She wouldn't let us sell the house. She says, we're living in a house we don't live in in a town we don't want to be in because we combine the assets. By keeping your assets separate, you control everything. Nobody has anything to do with this but you. 3 good things happen. First thing that happens is you have control of the asset. You make your own decisions. You don't need permission from anybody. The second thing is you have no liability. If she gets a divorce or doesn't pay her bank account bills, etc., your assets are protected, not being involved with her. And the third benefit is after you die, your family, your daughter in this case, will inherit these assets at what's called the stepped-up tax base. That means the current market value. You have a house worth $1,000, she owns it for $300,000. When you die and she sells the house, she doesn't have any capital gains tax to pay, no inheritance tax, no gift tax, and you maintain control of the asset the rest of your life and pass it on at full value after you die. That's why this is so valuable for you. This allows you to control your assets the rest of your life, buy and sell things, open and close accounts, make every decision, and know for certain after you pass, these assets will quickly go where you want them to go. Another question that we often get is this. This is, I already have beneficiaries on my life insurance and my 401ks. Those aren't going to go through probate, are they? No, they won't. If you have a beneficiary on these accounts, those assets will pass without the probate process. But I would caution you, my wife and I, our children are not the beneficiaries of our assets. We love our kids. We want them to get the assets, but again, we want them to get the assets through the trust. Judy and I are each other's beneficiary, but our trust is the alternate beneficiary. And the reason for that is if something happens to the beneficiary that's not good, that's detrimental for you, it doesn't affect that asset. A couple of examples would be this. Had somebody come to a meeting one day. She said, my parents had a $200,000 IRA. I was to get half. My brother was to get half. We were close family. My brother lived near them, so they named him the beneficiary of the IRA. Well, my parents died. Months and months and months went by. I hadn't heard from my brother. I called him and I asked him when he was sending me my $100,000. He said, what are you talking about? She said, remember Mom and Dad had the $200,000 IRA. I was to get half and you were to get half. Yes, I remember that. She says, where's my half? He said, if they really wanted you to get half, your name would have been on that check. Your name wasn't on that check. I'm not giving you that money. She said, my brother stole $100,000 from me and I had no reason of recourse of any kind because of the way that asset was held. Now, you do need a will. This is a special type of will. It's called a pour-over will. P-O-U-R, pour-over will. It has 3 purposes. First, it supersedes any will you've ever had. So all your old wills are canceled. You've got a new will that cancels the old will. You may have words of wisdom for people. You may have animals you want to leave to somebody and money for them to take care of these animals. That's made known in the will section of the trust. And then after you die, the will actually pours over into the trust. It becomes part of the trust. There's nothing in it that's probatable because we've made sure that all the probatable assets are titled in the name of the trust that you control. Now, there's also a section called distribution of assets. You know this as beneficiaries, who you're going to give everything to. Everybody is different. My wife and I did it all in percentages. We left a percentage to our church, to charities, to our grandchildren. The rest we left to our 2 children. We said we did not want the grandchildren to get their inheritance all at one time. What's the first thing a 16-year-old will buy? Of course, it's a car. Well, we wanted to make it easy for them to get the assets, but in certain increments. We also stated if they need the money for college education or health reasons, their guardians can use the funds to take care of that. Now, you may have all kinds of incidental items and things like that. You can be as specific as you would like. You can identify every item you have. You may have somebody in your family you have no relationship with of any kind. You don't even like this person, so you don't leave them anything. And maybe a few years later, there's a reconciliation. And now you would like to leave little Timmy something. What do? Change the trust. Remember, it's revocable. You can change it whenever you'd like to. Having a revocable living trust allows you to do that. So you'll distribute your assets. You may have incidental items, but be as specific as you need. If you wake up one morning and you think somebody's going to fight over your putter, you need to change your trust. If you have an inclination that somebody will fight over something, the likelihood is they will. So you may as well do that. And remember, it's revocable, and you can do that when you'd like to. Then there's a section called funding in your trust. Funding means getting your assets in the name of your trust. Your real estate, your bank account, your stocks, your car titles, any probatable asset should be titled in the trust name. The reason for that is if they are not in the trust name, those assets still go through probate. The trust doesn't protect them. In all the seminars that I've done, I've never had anybody come to a meeting that has a trust that has their assets in it. Lots of times they'll have their house in it, but nothing else. Most of the time they don't have anything. So one of the differences between what we do and others, we will make sure your assets are titled in your trust name. As I'm discussing this with you, keep in mind, you have total control. We have no control over your assets. Your bank accounts stay where they're at. Your real estate stays where it is. The difference is when you get your property tax bill next year, it will come to your home, but instead of saying your name on it, it will say your name, trustee. The tax amount would be for the exact same amount of money. The difference is when you get the bill, it will say trustee on it instead of just your name. Having it that way, it allows you now to live your life, accumulate your assets. They're in the name of the trust, remember, and after you die, your successors now have access to those assets so that they can be distributed properly. One of the questions I get often is this. When I do my trust, and I make a change to the trust, do I have to notify you every single time I do something? No, you don't. When you buy a new house, you buy it in the name of the trust. When you sell a house, it's automatically out of the trust. So there's no special things you have to do. Same thing with your bank accounts. You don't have to change anything regarding that. You don't change how you write your checks or how your checks look. You don't change how you file your income tax returns. You don't change how you receive Social Security, pension, rent, payroll checks. Everything stays exactly the way it is today. The difference is this. When those checks get deposited, they will automatically be in the trust. Because remember, the account is in the name of the trust that you control. If you don't like Bank of America anymore, you go withdraw your money. You don't have to notify us every time you open and close an account, like I said. You still control everything just like you did today. The difference is, after you pass, these assets will be eliminated from the probate process, and you will control everything as in the past. There's a couple of other crucial documents that are included in our living trust package. First is a living will. A living will is a document that allows you to determine if you're going to be kept alive artificially or not. Have a breathing tube, a feeding apparatus, whatever it may be. Without this document, you will become a ward of the state. The state will make those decisions for you. Those are crucial life and death decisions that you need to make. If it's a joint trust, obviously there will be a separate living will for each person. And then finally, there's what's called a power of attorney. You've probably heard this word before. Some of you may have a power of attorney, but power of attorneys have changed over the years. So we're going to include proper power of attorneys for each of you. A joint trust will have 6 of them. There's one for asset management. There's one for healthcare decision. And there's a recent new one for mental health decision, a very crucial document. Those are included in the estate plan package through our company. Now, the advantages of having a properly prepared power of attorney is that if you appoint somebody to make these decisions for you while you're alive, if you become incapacitated, somebody can do that for you. Do you know that your wife cannot make those decisions for you? Your children, they don't get to do that. Not unless they're first appointed by the state. And then you've become a ward of the state, and the state's going to make all the decisions for you, appoint somebody to do this, spending a lot of money naturally, and then every time they make a decision, they have to get approval from the court. That's what you're trying to avoid. These are crucial documents. Our program is all-inclusive. It includes all of your power of attorneys, your living wills, your wills, the trust abstract, ongoing consultation, as well as any legal consultation, etc., that you will need. Thank you for watching our Learn Living Trust webinar. If you have further questions or would like a free consultation, call today at 800-350-6376. If you call within the next 30 days and mention the webinar, you'll receive a $300 savings off your Living Trust package. Don't miss out. Call 800-350-6376. Call today. Plan for your future and have peace of mind.